of Ohio versus Emily Nutley. Good afternoon, Ms. Nutley. And the case number is B24-04985. As a reminder, we are here because Ms. Nutley has changed her plea, and I found her guilty of 2 counts, counts 1 and 2, of sexual battery. Those are felonies of the 3rd degree. They each carry a maximum prison term of 5 years. I have requested a court clinic report, a pre-sentence investigation, a victim impact statement, an officer statement, and sentencing memoranda from both the state and the defense. I have received all of that. I will say that the sentencing memoranda from the parties was 144 pages, and I have read it all, in addition to everything else that we requested. Has everyone seen all of those documents?
Yes, Your Honor.
Yes, Your Honor.
So maybe I should start with, could you put your appearance on the record and who's with you at counsel table?
And sorry, what did you say, Your Honor?
And who's with you at counsel table?
Okay, Your Honor, this is lead detective on this case, Sergeant Kao with Springfield Township Police Department. I'm Elise Cedars on behalf of the state. This is an intern who is with our office this summer. Thank you.
Good afternoon, Your Honor. Joe Surrey on behalf of Ms. Nutley, who's seated to my right.
Thank you. We have an application from the media for permission from me to broadcast, televise, photograph, or record the court proceedings. I believe that all the media have signed the form. Is there any member of the media, let me ask it this way, is there anybody here recording that did not sign the application form? No, people in the back of the room. All right, how about in the jury box? You've all signed. Did you sign?
The inquirer has signed, but I have not.
And are you with the inquirer?
Yes, ma'am.
That's good. Anyone else?
My reporter signed hers for me
Okay.
with 12.
Jennifer,
Yes.
all right, gotcha. You're on here. Anyone else? All right, so unless you or one of your colleagues from your outlet has signed this form, no one in this room is allowed to record the proceedings. That means if you have a cell phone, please turn it off and make sure that it is not recording. And for those of you who have signed this, I do grant permission for you all to record. A couple of rules. My bench is off limits. So anything on my bench, you cannot, me is fine, but not the papers and my notes. Understood? All right. Counsel, speaking to their client, off limits. You cannot, I have been on TV, somebody zoomed in on me when I was a lawyer, and my staff was watching the live stream and they knew exactly what I said because they could read my lips. So none of that. If the attorney is talking to Ms. Nutley, then turn away from them and do not record or broadcast that. Any questions about the rules? Okay. Then I will grant your request with a caveat that the victim, and his parents are not to be recorded. That means you're not to use your camera or your sound device to record their image or their words or anything that they say.
Parents, she told us we could do the voice, not the victim who's not even speaking. But
I'm sorry to interrupt, Your Honor. I am okay with the parents' audio, just not their faces or names. And then I will be reading what the victim wrote. And they are seated in the back.
Nobody,
corner.
don't, sir, we just make sure that you're not recording where she pointed to.
No, it's not.
Thank you very much.
So the parents can be audio recorded but not video recorded,
Yes.
and the victim's not speaking.
I'm speaking on the victim's behalf. Yes. So just, yeah, any identifying factors, really just their names, I would ask that those aren't published.
So I will change this to the witness and the witnesses, the parents of the victim, object to being recorded by video and identifying their names. Otherwise, you may record their voice.
Your Honor, thank you. I did also speak to members of the media. I did ask, and I'm really just asking the court, if I do accidentally say the victim's name, or the detective does, or his parents do, if we could please strike that and not publish that.
All right, so I'll add a further condition to the order, and it says to redact the names of the victim and his parents if it's accidentally stated on the record. Does everybody agree with that?
Yeah, we bleep it out.
All right. I don't care if you don't agree, that's the order. All right, so I will grant your recordings with that caveat. A bailiff will get that filed, and if anybody wants a copy of that to take back with them, please help yourself. We'll make copies for you. It is a new form. The Supreme Court has new rules, and we're trying to adopt them. So any feedback you have on those is welcome. All right, so back to our hearing. I am, since I have read everything, I would like to start with the defense, because you have the opportunity for mitigation. So I'll hear you and any evidence and argument on mitigation, and then I will turn to the state for their position on sentencing, and I'll come back to the defense if there's anything you would like to respond to from the state. All right, you may begin.
Thank you, Your Honor. Judge, as you know, the state has presented a memorandum asking for a 5-year prison sentence in this case. But respectfully, I believe that their request overlooks some key facts that are critical to the court's duty to impose a sentence that is effective, proportionate, and individualized under Ohio law. The prosecution argues this is a more serious offense because of the harm to the victim, Emily's position of authority, and her actions during pretrial release. To be clear, the harm here is not to be minimized, but harm alone does not mandate prison. The position of authority or trust factor should not be considered as an aggravating circumstance for sentencing purposes because it is an essential element of the offense itself. The statute criminalizes the conduct specifically because of the relationship between the defendant and the victim, such as teacher and student, coach and athlete, or other similar positions of authority, making the existence of that dynamic a foundational requirement to the offense to be charged. In such cases, and in this particular case, it's not the conduct alone that constitutes the crime, but rather the breach of trust inherent in the defined relationship. Elevating this factor as a separate basis for increased seriousness or punishment would result in improper double counting, as it would punish both the defendant for both committing the offense and again for satisfying a necessary element of the offense. In other words, Your Honor, the state's argument that because of the relationship, that is a more serious factor. It is not, because it is necessary as an element of this offense.
So are you saying that I should ignore 29, 29, 11, and 12?
No, what I'm saying is that the state is arguing that the relationship between Ms. Nutley and the victim should be considered a more serious factor in the court's analysis. But it's not a more serious factor because it is a necessary element of the offense.
I guess you were asking me to ignore the statute.
No, ma'am. The statute, the conduct constitutes the offense. The nature of the relationship is the offense. It does not then get double counted as a more serious factor in the relationship or this court's determination in sentencing.
So in 29.12b, one of the factors that I am to consider to decide whether the actions in this case were more serious than normally would constitute this offense,
Right.
Sexual battery. You're saying I should not consider the factor that the offender held public office or a position of trust? the offense was related to that position.
As a more serious factor, correct, because this offense cannot be committed without that element.
Where is the Jimmy authority?
Well, it's, do I have a case to cite to you right now? No, Judge, but the fact is it would be double counting. The plain language of the statute supports that argument that the more serious factor of this offense doesn't exist because the nature of the relationship is required to commit this offense. Also, Your Honor, the state's assertion is that there's a lack of remorse. That's contradicted by every therapist report. Emily's own words, she submitted a letter to the court that was attached to the sentencing memorandum. She would also like to make a statement to the court this afternoon. And the words of her family and friends. You saw in the sentencing memorandum multiple letters that were submitted on her behalf. What she lacks, Your Honor, is deflection. She takes full responsibility for her actions without excuses and without shifting blame. She openly acknowledges the harm she caused and confronts it head on. Rather than minimizing her conduct, she has committed herself to meaningful change through consistent and ongoing therapy. Her response is not one of avoidance, Your Honor, but of reflection, growth, and a sincere effort to make amends. The state also cites to this court a pretrial misstep trying to deflect against the fact that Ms. Nutley has no prior criminal history. This pretrial misstep was her attempting to drop off Christmas gifts to staff at St. X. Emily contacted me to see if that would be acceptable. I spoke with the prosecutor's office and it was determined that in fact it was not acceptable. That was stopped. The gifts never got delivered. The issue was brought to the court's attention. It was addressed and there have been no violations since then. That moment is not evidence of defiance, Your Honor. It was an isolated lapse by a woman in an emotional crisis who's since shown full compliance. The statute directs the court to consider the least restrictive sanction that accomplishes the purposes of sentencing. Community control with appropriate conditions meets that standard. Emily's already been subjected to extraordinary and irreversible consequences. She has lost her career, she has lost her license, she has lost her marriage, and her place in the community. She will live under...
Are those things I can consider under the sentencing factors?
I believe that you can. She's also going to be a Tier 3 registrant for life, meaning that she has to register every 90 days for the rest of her life. This is real punishment. It's immediate, it's ongoing, and it's lifelong. She's been assessed by multiple experts, Your Honor, including the court clinic and the Hamilton County Probation Department, and deemed to be a low risk to reoffend. In fact, her risk assessment was so low, it needed to be manually adjusted up just to qualify her for supervised probation instead of unsupervised probation. She's shown insight into this. She has engaged deeply with the AWARE program. I attached the information to the sentencing memorandum as the court's aware. That program is a sex offender program that is certified by the Ohio Department of Rehabilitations and Corrections. Dr. Bassman's report was attached to the sentencing memorandum, and she is actively participating in that. The AWARE program is an ongoing trauma-informed therapy tied to her own history of childhood sexual abuse and untreated mental illness. Your Honor, the state completely ignores the PSI and the court clinic report in its sentencing memorandum, not to mention the reports of Dr. Bressler and Dr. Bassman. Now, this quote from Dr. Bressler's report.
I'm not sure
Of course.
it's even possible, but your lectern is blocking my view of this.
Oh.
And I was wondering, hang on. Maybe we should just solve the problem. Thank you.
Okay, sorry.
Because there are all those microphones.
Yeah, there's a lot of cords there. Your Honor, Dr. Bressler, to quote his, Dr. Bressler, to quote his report, Dr. Bressler states that he hopes this court will take into serious consideration that there is no evidence to indicate Ms. Nutley is in any way at significant risk for criminal recidivism. There is no evidence of any previous criminal history. She does not meet the definition of a psychopathic offender, nor is there any indication that she has deviant sexual interest, putting her at risk for future sexual offending. Plainly stated, Ms. Nutley is a broken woman, a mother of 3 children, plagued by both mental illness and substance abuse issues. Dr. Bressler and I both hope that the court will take that into consideration when fashioning the sentence. Dr. Bassman echoes those sentiments to the extent that he is indicating that she is making progress in the AWARE program with himself and his clinicians. This is an emotional case for everyone involved, but the facts and information support a sentence of probation. Prison will not increase public safety. It will halt the rehabilitation that's already in progress. It'll expose her to credible threats of physical harm and sever fragile family bonds. Probation is not leniency. It is supervision, treatment, monitoring, and consequences that align with the purposes of the sentencing and the realities of this case. It does not demean the seriousness of this offense. It serves all the purposes of the sentencing, and we respectfully urge the court to impose community control with the appropriate sanctions. Thank you.
Do you have anyone who would like to speak other than Ms. Nutley?
No, Judge, I spoke with the family, I spoke with Ms. Nutley. They have submitted their letters. They are present here, but the letters will suffice for what they wanted the court to be aware of.
I have read the family's letters on behalf of Ms. Nutley.
Thank you.
And then Ms. Nutley, at sentencing, you are not required to speak, but you're welcome to speak, and I certainly will consider whatever you say in my decision.
Your Honor, thank you for allowing me the opportunity to speak. I stand before you today overwhelmed with shame, guilt, and regret. There is no excuse for what I did, and I will not try to offer one. I crossed a boundary that never should have been crossed, and I violated the trust of someone who needed to be protected and respected. I live every day with the heavy burden of knowing that I caused that harm. I see clearly now that the way that I acted was clearly out of line, not only with the law, but with the basic human decency that I've lived my whole life trying to live by. I carry that truth with me constantly, and it makes me sick. I think every day about the impact of my actions, not just on the victim, but on his family, his friends, and the entire St. X community. In addition to losing my job, the license to do what I love, and being registered as a lifelong sex offender, I've lost my husband, my home, my family, my friends, and my reputation in the community that I love. I'm a mother of 3 children, and I have to look at them knowing that I've failed them in the most serious way imaginable. Instead of being viewed as their role model, I have caused harm and embarrassment. I will never stop feeling the weight of that and will spend every day to attempt to rebuild those relationships. I'm asking for the opportunity to prove myself on probation where I can continue rehabilitation instead of incarceration. I do not take that lightly, and the lifelong consequences of my actions are felt every day. I will continue my 2-year treatment program that I'm already an active participant, and I'm committed to take every step required of me to serve our community. Not because it's mandated, but because I owe it to the court, to the person that I've hurt, and to myself. I'm engaging with professionals who are helping me understand why I made these choices and how to take responsibility for every part of them. I wish more than anything I could go back in time and undo the choices I made and the boundaries that I allowed to be violated. I always got everyone else the help that they needed, but failed to look in the mirror when I was at my own lowest point. I wish that I'd asked for help sooner. I'm not asking for forgiveness because I've not earned it. I know that people may just see me as my worst mistake, and maybe that's what I deserve. But I will spend the rest of my life trying to make amends through my actions. Thank you, Your Honor.
Anything further?
No, Your Honor.
Ms. Peters.
Thank you, Your Honor. I did prepare a slideshow in this matter. Here's a copy for you. Your Honor, may I approach?
Yeah.
I will get to the slideshow in a second.
Did you?
I did, yeah, I did. Your Honor, I'd like to start with the most important person here today, the victim in this case, who is present in the courtroom. He's prepared this statement for me to read. Judge Branch, thank you for listening to me and for reading all of my family's letters. This entire situation altered my high school experience and altered my life. It left me confused, lacking self-worth, and depressed. When the abuse started, I didn't realize how I was being taken advantage of. I didn't know what grooming was until I was sitting in class after it had happened and realized that's what she did to me. I really did not want to have sex with her, but she insisted. She would not leave me alone. She told me she would kill herself when I tried to end it. I didn't know how to get out of the situation. I finally decided that I didn't want her to do this to anyone else. I told the truth. What transpired after was even worse. The social media, constant harassment and pestering. Even this past weekend at my state championship, the other team student section yelled, "Where's your teacher?" and her name through the whole game. I can't get away from this. I have a hard time trusting people, especially authority figures. Judge Branch, I am respectfully asking that she be given the maximum penalty, being 10 years. Thank you. Your Honor, next we will hear from the victim's parents. They would like to address the court.
Good afternoon. Thank you for coming.
I'm the victim's mother. 4 years ago, we made the decision as a family to send our son to an excellent high school where he would meet other like-minded individuals. He never understood why the boys in his hometown growing up and playing sports didn't have the same drive and determination to achieve as he did. When his friends were tired of practicing or playing, our son would make up games or competitions to play against himself. We felt that making the commitment to send him to a high school such as St. Xavier would give him the greatest opportunity to meet other young men who had a similar drive to compete on the athletic field and in life. Before the beginning of his freshman year, we were told at a parent meeting that the St. Xavier community promised to come alongside us and help us grow our son into an academically accomplished man for others who would be ready to successfully carry out God's plan for his life and to serve as a leader in his community as an adult. We believed every word of this promise and moved forward with making the sacrifice to send him to the St. Xavier community for his high school years. In our hearts, we knew this decision would be the best decision to enable him to reach his full potential, both academically and athletically. Had we chosen to send him to our local high school, he would have traveled 1,440 miles to school and practices over the 4 years. The reason I stated that we chose to make the sacrifice to send him to St. Xavier is because over the last 4 years, he has traveled well over 75,000 miles. I only share that to say for over 37,000 miles in the last 2 years of his high school career, our son has been forced to drive over 2 hours a day to a place that has caused him extreme emotional pain and humiliation. No one would ever force a victim of sexual assault to return to the scene of the assault day after day, causing the trauma response to reactivate in their brain. However, due to the defendant's actions, that's exactly what our son has been forced to do, just to be able to graduate from high school. As I stated in my impact statement, the entire tone of our home changed due to our son being the victim of this crime. He broke the glass out of our front door 2 times over the last 3 months from slamming it in anger as he left the house. His reactions to situations were completely irrational. Both of our sons have had to go through counseling to attempt to mend their relationship with each other. Our son has since quit counseling after a few sessions, as this trauma has caused him not to trust anyone, especially new people. He used to be a child who believed the best in everyone. Sadly now, he constantly questions people's motives. A brain affected by trauma is changed forever. and this will always be something that he will have to live with. In the case of his athletic career, this crime has absolutely destroyed his confidence in himself and his confidence to leave our home, live independently, and play sports in college, which was always his dream. His drive and determination to win and compete were like no other child I've ever known. This repeated assault has ripped all of that away from him. What should have been a junior and senior year of joy in playing the sports he loves with his friends, has turned into 2 years of hell and shame, being talked about online and at school from people who had no idea of the pain and suffering he was going through. This crime has ruined who our son was as a person and an athlete due to the constant torment he was going through from other students, teachers, and strangers. I'm thankful that our son was brave enough to be willing to tell the truth and suffer all of the shame and harassment in order to stop her from victimizing even more additional children in the future. Thank you.
I'm the victim's father. You know, as a father, your job is to protect your child and to give them what you didn't have, because my ceiling is his floor. And through the years, our ceiling got higher and higher. I started at a very low poverty level, and I always told him, you can do what I can't. I victim myself. And I understand the lens of trauma that you look through forever, because the paradigm shifts. Those you're supposed to trust do heinous things. They don't take into account that you're just a child with a child's brain. And that trauma never goes away. We deal with it, but it never goes away. And my job as a daddy, ever since the day that I found out that I was having my first child, was that they will never have to face the demons that I've already fought. So we sought out the best places for him, whether it would be sport or academics, and that being St. Xavier High School. And we really thought that we had found the culture and community where he would be safe, where the monsters didn't live. I didn't have to fight the monsters because I had monster fighters with me. And that was true. All in one. So as I stand here today, and my son and my wife told you about his academic power, his athletic prowess, and he was a great athlete, and his whole desire was to be the athlete of the year, or be the athlete who competed at the highest of levels. And in his junior year, he couldn't even stay healthy because he was so sick. His whole junior year in lacrosse, he was sick, and everyone thought he had mono, and he had him tested for multiple things. But the guilt that lived inside of him, we live a life of principle. We live a life according to the Word of God. And we put things into our children that you respect authority, and when authority tells you things, that you can usually trust them. And that it's okay to trust someone who is in authority over you, because that's what we do. Now that this has happened and his life has been shattered, his all of the aspects that he would have, the respect that he would have for authority is gone. He doesn't even have authority for me anymore. Because of the anger, the hurt, the anguish that my child has gone through has destroyed my relationship with my son. And there's nothing more sacred to me than the love of the father for his son and the son's love for his father. I have 3 boys. And we have been so tight all of our lives up to this point. And when that happened, it shattered everything, and that's not something that you can get back. But I also know that it's something we can stop from happening to someone else. It seems to be rampant across the nation, and I'm a pastor as well, and I deal with people who always, they're afraid of letting their kids go places because of what we see in the media, because of what we see on the planet today. And I would ask you, we would ask you that you would give her the maximum sentence, to set a standard again that no is no, wrong is wrong, that those who are given much are required much, and those in authority are judged at a higher standard because of the authority that we have in people's lives. I've coached for the last 25 years. I own a gym where I train athletes. I pastor a church. All of those places of authority mean that I'm held to a higher standard in the things that I do, the places I go, the things that I say and do, the things that I put into children's minds. Those things I'm accountable for. And I don't have the right to twist. I don't have the right to change. I don't have the right to do anything but live the middle of those children. We can't violate those kids anymore. And we're asking them to do what's set the standard and give them the maximum.
Thank you.
Your Honor, one last speaker before my presentation, Sergeant Kao, Princeton Township Police Department.
Good afternoon, Judge. Like you said, I'm Sergeant Kao with Springfield Township Police Department, and I was the lead detective in this case. I know that in my officer's statement, I stated that I thought 12 to 18 months in prison would be fair.
I did notice that. I did notice that you said
Okay.
that sentence.
So I've sort of reconsidered my opinion on that, and there's three factors of why I've reconsidered. With Miss Nutley's lack of accountability is one. Number two is her not being apologetic of the trauma that she's caused. I don't think in her letter to the court that she said sorry one time. And then attempting to place blame on the victim, in my opinion, that was the biggest thing that sort of changed my opinion. I just can't believe that she would try to point the finger at him and blame him. But because of those three factors, I do wholeheartedly agree with the prosecution that 5 years would be a fair and appropriate sentencing. Thank you.
Your Honor, as for my presentation, of course I'd submit on my memorandum, but I have prepared this slideshow. On my memo, you probably saw on the first and last page there is a typo. I put ODCR instead of ODRC. I don't know how that happened, but the state is asking for 5 years in prison. I'd like to begin by asking the court to imagine if these same facts were a male 43-year-old counselor and a 17-year-old female student. Does that defendant go to prison? I believe the answer is yes. Why should this case be any different? And kind of in response to the defense about the sentencing factors, I'll get there in 1 second, but I did do a quick search of the case law, and it seems to be that these factors are absolutely to be considered by this court. I think that there is one case I found from a county in Northeast Ohio that talks about not using an element of the offense in a factor, but it's for consecutive findings. Those factors that you can consider and in giving consecutive findings, but also that was reversed too. So I think that absolutely you are to consider these factors. Obviously, this court knows the purposes of sentencing are to protect the public from future crime by the offender and others, to punish the offender, and to promote the effective rehabilitation of the offender. And of course, the purposes of sentencing kind of mirror the principles of sentencing. I don't need to read these to the court, but this is an F3, so the court is guided to weigh these certain factors, decide whether the defendant's conduct was more serious or less. So I kind of talked a lot about this in my brief, but I wanted the takeaway from my brief to be what sentence would not demean the seriousness of this offense and its impact on the victim. I apologize, Your Honor.
Victim?
So these are the factors that are applicable. There are 9. But only 6 are applicable, and all 6 of them apply in our case. So first, of course, the injury was exacerbated by the victim's mental health, or mental condition, or age. The victim was at the learning center for a reason, to get help. The victim was vulnerable due to his state at the time. The victim was only 17 years old. This was a child. At 17, a brain is still developing, particularly the prefrontal cortex, which is responsible for rational thought, planning, and impulse control. Second, victim did suffer psychological harm. The victim suffered serious emotional distress that affected and still does affect his mental well-being. Third, obviously, Nutley held a position of trust. Fourth, Nutley's occupation was to protect these students. She even signed this protection policy that was an exhibit in my memorandum. The school required employees sign this. She said that she would report the abuse. Fifth, her occupation facilitated the offense. She gained access to this vulnerable 17-year-old because of her job. And her conduct does and will influence others' conduct. Six, her relationship with the victim facilitated the offense. Nutley, once becoming friendly with the victim via text, began to groom him. She gave him her Netflix password. She bought him lunch. She got him out of detentions. And eventually she moved in to make it sexual. The factors that would make the defendant's conduct less serious, none of them apply here. The first one is victim induced or facilitated the offense. No. The victim did not incite the defendant. And I'll get to this later, but the defendant was the aggressor all along. The offender acted under strong provocation. No, she's 26 years older than this kid. Offender did not cause or expect to cause physical harm to persons. She knew, Judge, she is educated, specifically on what type of abuse, what this type of abuse does to a child's brain. She was just too selfish to care about the harm she caused to her victim. Do substantial grounds exist to mitigate the offender's conduct, even if they do not constitute a defense? No. Her drinking habits? No. The abuse and harassment cited to Dr. Maddox are undocumented, but even if true, they don't excuse the abuse that she then manifested on the victim. In fact, if true, it's all the more reason she should recognize the damage she was doing. The recidivism factors. There is one thing I didn't put on there under this slide, the grooming. I did want to add, just this grooming is learned behavior. So the defendant does know how to groom. She learned how to, over a number of years, how to manipulate victims, and this should be a concern as to the defendant reoffending. The concerning behavior post-indictment, the Christmas gifts, her new job since January 2025 that she told Dr. Maddox about is an online school or counseling of some sort. And I did research, and it's either for kids that are in 3rd grade to 12th grade or college students and adults. So the defendant clearly doesn't understand that she has no business educating children. She did not seek treatment until when sentencing was scheduled. She went to the Linder Center for 1 day. And by the way, she lied to the Linder Center and told her this never happened. Most importantly, Nutley has no genuine remorse. This, what you just saw, Your Honor, was an act. She has not cried one time since we've been sitting here. Once the defendant blamed the victim in her report, Dr. Maddox's report, I went back and read every single text message between the victim and the defendant in this case. As this court knows, I was not the original prosecutor on this matter. It was my co-counsel who is on paternity leave right now. As an officer of the court, I can tell you that this defendant lied to Dr. Maddox. She blamed the victim for initiating the sexual acts. This was all her. She blames the victim for coming after her when she was intoxicated. Yet she texts him plans to go to happy hour and then come back to the school and fuck him. I did prepare a comparative analysis. I I tried to keep it within the topic of student-teacher abuse within the Cincinnati area. I was surprised to find this happens a lot of times. It is pretty often, too often. I remembered a couple of them. Stacy Schuler from Mason, she received 4 years. Julie Houtenroder, 2 years. The list goes on. I did want to correct one. On number 5, Justin Madden, I put 93 months. He actually got 3 years. It was a media article that pretty much didn't realize that they were run concurrent. Quincy Scott, Your Honor, I included this one because this was a case in your room. The defendant did not have a record, but abused his power in an unacceptable way, preying on those he was supposed to be protecting. Much like this case, what makes our case worse, though, I think, is that this was a prolonged period of time, a long period of abuse and suffering by this victim. But I will get more into that in 1 second. The defense cited a case in their memorandum. I looked up the case number and talked to the prosecutor that was on that case as I supervised him. He told me that the defendant pled to 1F4, unlawful sexual conduct with a minor. He said that it was 2 strangers and the defendant did not know the age of the victim. And Judge Cross put that defendant into River City. So this is kind of the crux of my entire argument, why this defendant deserves more than those other teachers that were just mentioned. For one, her specific job title and duties, the personal information that she knew about the victim. She was not just a teacher, she was a counselor. She was actually in charge of the counselors. She was supposed to be helping high-risk students overcome their challenges. Her job was specialized to focus on the mental and academic health of students, and she did the exact opposite here. She knew intimate details about the victim, and she took advantage of an already vulnerable kid. Multiple allegations of abuse. Your Honor, the defendant did plead to 2 counts of sexual battery, one being fellatio and the other vaginal intercourse. But there are many acts that took place here, including in the text message that I reviewed. The disgusting text messages. This is a text message that I found within the Cellbrite extraction report. The time is in UTC, so it's actually -4 hours. I screenshotted this for the court, and there is a note that this is not even close to the worst of the worst text that I read from the defendant, but it does underline the type of confusion that the defendant caused this child. Miss Nutley wrote, "What would be wild is that when the whole school is at mass, I'd give you the best head of your life in my office." And head means fellatio. Another reason that the defendant's conduct was worse than the average teacher and those comparative teachers that I mentioned before, the defendant stole the victim's innocence. This is a fact that I contemplated bringing up because I did not want to embarrass the victim. Not that he should be embarrassed, but losing your virginity is supposed to be special, with someone you love, a sacred act, and Nutley took that from the victim. She stole it. Here is a text that I found that sheds light on the evil nature of the defendant's mind games. Emily Nutley. Here's my question. Number 1, do you want to wait for someone you actually care about? Or 2, are you down for having amazing sex in the meantime? The explicit photos sent to the victim, they are a representation of the predatory behavior. She wanted him, a kid.
And I want to see, or have anybody brought
I will, no, Your Honor, I did not include the photos. If you would like to see them, I have them with me, but I did describe them for the court. She did want a kid to want her, and he was turning her away. He told her he did not want to do this anymore. And she likely felt rejected, but it's clear she wasn't going to take no for an answer. So, like I said, I wasn't going to show the court these graphic photos.
I don't want this slide to be broadcast.
Okay.
It's not in the record.
Okay, Your Honor, no problem. They are graphic, and they were sent to the victim. The defendant did also solicit pictures of the victim. But what's really truly the most egregious part of this case is the manipulation that occurred throughout this timeline. The defendant was seeking victim's attention. She begged for him to be back in the learning center. She would offer him food. She would get angry, and he would avoid her in the hallways. We would be here till next week if I told you about all the manipulation that took place, but there is one more text. This is the last text I'm going to show, Your Honor, and it truly does explain it all. So this is after the sexual acts that the defendant pled to, and pretty much after the conclusion of all sexual acts. It says, if your grades drop below 80, you will be required to come on E-days, in addition to flexed help for French. No more special treatment, just like everyone else. And I was talking to a few coworkers, and one of the male coworkers said to me, obviously she gave him special treatment. And I said, yeah, but the point of this text is to show that she was using that treatment from before to try to get the victim to act a certain way. She is telling him he will not get special treatment unless he continues the relationship. That's what's so appalling about this text. Next, the cover-up in this case, the defendant gave victim $100 a month. She let the victim use her pickleball membership. She bought him lunch randomly, as I already noted. Blaming the victim. The fact that the defendant blamed the victim in this case is astounding to the state. I know the court read my memorandum, so it's aware of my disdain, but I have to say it is purely cruel to abuse a child and then act as if it was their fault. This victim feels extreme guilt. He has been drugged in the media, harassed, he is hurting, and he will be for a long time. His relationships now are all going to be skewed by the way she changed his brain. He will put these painful memories on a metaphorical shelf in hopes to never remember again, but they will come crashing down on him at some point without his doing, because of what she did. His mental health is at risk. And for all the men and media in the room who think, boy, this female prosecutor doesn't think this kid is fine. He's a legend, he slept with a hot teacher, he's the man. They should be ashamed of themselves. If you're thinking that, I guarantee you haven't been in this position because you feel awful for the victim. You'd know the long-term effects of this, and your archaic reaction is what makes the victim feel even more alone, even more depressed, even more confused, as I mentioned in my brief, Your Honor. Protecting the public is big in this case because of the defendant, as a teacher, served the public. This case has gotten a lot of media attention. If you look around the room, that's obvious. On Facebook last night, there was an article posted with a comment section. Some of these comments were truly concerning. I saw one comment that said, arrest the kid, and another, where were teachers like this when I was in high school? I saw another saying, she'll get probation while a man would get years in prison. They were unbelievable. This is a victim. Little girl or boy, male or female defendant, it does not matter. Someone, and possibly Your Honor, can put a stop to this rhetoric. There is an upward trend of teachers who are doing that. And to that point, the city and the country needs to be shown that this behavior is unacceptable. Your sentence, Your Honor, should deter others from acting this way. What kind of message does it send if the same ex-teacher who slept with her student doesn't go to prison? The person or teacher who is grooming some child out there sees a probation sentence in this case and thinks, well, maybe I can have sex with the student I'm grooming and not go to jail. One other point from my brief, Your Honor, was about the statute itself. It exists for a reason. The protracted sentencing guidelines also exist for a reason. Emily Nutley used his vulnerability against him for her own benefit, for her own sexual gratification. She stole his innocence. She deserves to spend multiple years in prison for it. And the Wade sentencing factors call for a prison sentence. The state of Ohio is respectfully asking for 5 years or 60 months in prison. Thank you, Your Honor.
Would anyone else like to speak on behalf of the city?
No, Your Honor, thank you so much.
Anything you'd like to say in response?
Yes, sir. You know, I'm left with a really difficult position here because on one hand, I need to address the state's arguments. On the other hand, I don't want to appear as though I'm diminishing or minimizing the effect on the victim or deflecting responsibility away from Ms. Nutley. So please take what I'm saying with that caveat. I think really what we listened to just now is an attempt to inflame the court's emotions. And there are a couple of reasons why I say that. One is she cited two Facebook comments and then placed it on the court's shoulders to stop the rhetoric in Facebook comments that have nothing to do with anybody involved in this case. That's not the role of the sentencing. That's an emotional reaction that's trying to be elicited from the court. Ms. Dieters made a comment of, for all the media in the room. Again, this is a statement that is pandering to the emotional reaction involved in this case. As I said in my initial remarks, this is an emotional case for everybody. For Ms. Dieters, for me, for Ms. Nutley, for the victim, for his family, for the St. X community. Trust me, it's emotional. The lack of Ms. Nutley crying today in court has no bearing on whether she is sorry for this. I will tell this court, we have spent hours in my office with her in tears. My paralegal this morning told me that yesterday when Emily stopped by to look at some documents, that she spent an hour in the conference room with her, consoling her and talking her through this and the tears that she shed in my office. The fact that she's not sobbing in court, the government would like you to believe then that she is not sorry. That's not true. Additionally, in her letter to the court, she didn't say she was sorry. That's nothing but an apology letter. Maybe the word sorry is not in there, but it's an acceptance of responsibility and it's acknowledgement of the harm that she has caused, and it is the regret for doing that. She said she wished she could go back and do anything to undo this. She has lost her family. She has lost her license. She has lost her ability to live where she wants, the ability to move freely through society for the rest of her life. Every 90 days, she'll be checking in with the sheriff. So for the government to come up and say that she is not sorry, that that's fake, that it's contrived, is way out of line, way out of line. I will tell this court that I have spent almost 8 months working on this case with Ms. Nutley, and she is nothing but sorry. State wants to make an argument that, well, this is ridiculous that she's working at this online job where she's teaching children. She's not teaching children. She's working with college-age and adult individuals, and she doesn't even work there anymore. The court wants her to have a job. Society wants her to have a job. She got the job that she was able to, and then suddenly the government wants to say how irresponsible it is. It's not. The information that was put up in this slideshow today was salacious. It was there to invoke a reaction, and it is the reason we did not have a trial. Ms. Nutley stepped forward and took responsibility for her actions, but that's not good enough for the government. They had to put all that crap up on the board so that all of these cameras can see it, and so that this court can get inflamed and say, she's going to prison. I'm sorry, but look at the PSI. Look at the court clinic. Look at Dr. Maddox's report. Look at Dr. Bressler's report. Look at Dr. Bassman's report, all of whom say probation is appropriate, treatment is appropriate. Yes, this is a terrible crime. I understand that. We all understand that. But sending this person to prison does not further the goals of sentencing in this particular case. A community control sanction with the appropriate supervision and with the appropriate treatment, which she is already enrolled in, will more than suffice to meet the sentencing goals. And I would strongly urge the court to not have the emotional reaction that the government wants it to have, and instead look at this, as I know you will, Judge, dispassionately and analytically, and apply the appropriate factors, and that sentence will be probation. I believe that would be the correct one. Thank you.
Well, I would agree with the last thing you said, which is I will look at this the way I need to, because Ms. Nutley, this is a very difficult decision for me. The factors I have to consider include what's the appropriate punishment, what's necessary to protect society and the public, and what rehabilitation, and do you want rehabilitation, is possible. Every factor comes into play in this case. And what I have to decide, looking at each of those factors, is what happened. What I find frustrating about this case is that I'm the one that said bond. There was no OR bond, no EMU, and the prosecutor didn't want there to be any restrictions on the bail pre-trial. And I've never seen a case with these charges without some restrictions on bail, and I never understood this case until I got the sentencing memos on Friday. Because no one ever shared any of the facts with me, or any of the damage, or anything that happened to the young man in this case. And now that I understand everything that happened, I do think that the most important factor that I need to look at is what's the proper punishment in this case. So let me say that there's several rehabilitation issues here, and I take them seriously. Dr. Bassman has sat in this witness stand, and he has testified, and he has been cross-examined by me, and in many sexual offense cases, he's providing a report. He's got a great program. So does ODRC. Same program. I am concerned about the need for rehabilitation and the desire to be rehabilitated. I don't know how sincere that is, because Ms. Nutley didn't start until after she pled guilty. And I have seen many defendants in this courtroom begin their rehabilitation, begin their treatment the day they get arrested, the day they talk to their attorney, long before it comes to sentencing. And I have a whole long track record of how they were doing, whether probation was a good idea. And in this case, I don't have that record, and I'm not sure what to do about the fact that Ms. Nutley waited until after you pled guilty. But more importantly, no one's really addressed the alcohol substance abuse issue that was in a court clinic report and in the facts. It's my understanding from the facts that I was given, it was the officer's statement, the text messages, the information that I have is that she was under the influence of alcohol, drunk, 2 bottles of wine at the Christmas party at the school on one of these days that the sexual battery occurred. And there's nothing about that. I don't hear any treatment for alcohol abuse. I don't hear any acknowledgement that that is part of the problem, or any want to be rehabilitated. And I think when you look at the court clinic's recommendation that there be treatment for both sex offense and alcohol abuse, I think that makes this even harder for a person to be successful on probation. So when I look at the factors, yes, the victim in this case was 17 years old, a student at the school, being counseled and supervised by an educator who he trusted, a person in power over him, a person who was supposed to be protecting him. And it's that relationship, your power over him, that gave you access to him, that gave you the opportunity to commit this crime at the school. And that is all the factors that make this a more serious case than normally a normal situation that constitutes sexual battery, all weigh in favor of a prison term. On the other hand, recidivism is another factor I have to consider, and you haven't committed a crime, you haven't been prosecuted for anything in your life, you have not been accused of this behavior in any other way, and I am going to ignore the statements and the materials that I had that there may be other situations or there may be other children who didn't want to come forward. I really cannot consider that. So I am just looking at the facts of this situation. But when I look at recidivism and a low risk that you have of reoffending, I worry about the alcohol abuse again. Because if that is what was causing the behavior and the terrible judgment, is it the depression? Is it your own trauma that you've had in your life that you can get treatment for? You know how to ask for help. This is part of your training, and your job is to ask for help for your students. You know how to ask for help for yourself. But you didn't do that. And if you didn't treat your trauma, you didn't treat your depression, your substance abuse, then I do worry that there could be this could happen again. So recidivism is an issue for me. But really, this final factor that I look at is remorse. And I was so looking forward to you speaking today because I really wanted you to tell me that you were remorseful. And I didn't want you to use those words. I don't care if you don't say the word apology. But, what I was looking for was for you to say that you acknowledge the harm that you caused this young man and pretty much ruined the rest of his high school career. I didn't see it. I didn't hear it. I don't even know if you read the reports from his family, the letters from his family, but what I learned from reading that is that your behavior destroyed his confidence in himself, his education, his college career, his scholarships for sports, his relationships. He feels guilty. He feels shame, and he's the victim. Hear or see anything that you acknowledge that. Ms. Nutley, you caused him the same trauma you suffered as a child of sex abuse. You knew what this would do to him. He shut out his family. He shut out his friends. That whole period of time between, I don't know when the relationship ended. Honestly, I don't know any of the details about what happened after the last day in the indictment, December of 23, but it's not until October of 24. So 10 months. I see from the materials that you wanted him to keep your secret. And you encouraged him, and you paid him money, and you gave him favors, whatever you were doing. He was keeping your secret. That's what destroyed him. Because he didn't have family, he didn't have friends, he had no one to talk to. And the way his father described the way his life changed, and didn't understand what was going on with him during that time because he didn't know anything about the sexual abuse, and you're trying to make him keep this secret. He lived with his negative feelings. He felt guilt and shame. He was traumatized. He was not letting anyone help him because he was protecting you instead of you protecting him. Before the sexual offense, he had a mom and a dad and a sister and teachers who described him as happy and goofy and athletic and loving and hardworking, and a young man who had a great life ahead of him. And all of that is gone. He's not in treatment, from what I understand, which is very sad, because that's what he needs. He did not sign with any school, so he doesn't have a lacrosse scholarship for college. He lost his spirituality, he became angry and cynical, and he distrusts people. I didn't hear any remorse for causing any of that, and that's what I was looking for. And I will say to this young man, because I just described you in a way that your family and friends and teachers described you, is that it is my hope that when this case is over and I sentence Ms. Nutley to what I hope is a just sentence, taking all these factors in, that you will be able to see how brave you have been to come forward, and how courageous you have been to tell your story, first to your parents and then to the police. Because what you are doing is protecting other young men from being sexually abused by their teachers in many ways. Because you can show people you can be brave, and you can speak out, and you can tell the truth, and your life will get better. You don't feel that way today, I'm sure, but hopefully in a few years, in a short time, you'll be able to seek the help and the treatment that you need, and that you'll be proud of yourself for doing this. So back to the sentencing factors, I left off at remorse, which I do not find genuine remorse in this case. And there's another factor I wanted to address that the detective put in his statement, and the prosecutor, Ms. Dieters, mentioned about what happened in this case now that we know all the facts. What are they thinking about what's the sentence going to be? Because I agree with Ms. Dieters. If they think they're just going to get a slap on the wrist, then why not? And I do consider that to an extent. And putting this all together and thinking this through, and I have been giving this a lot of thought, because if anybody knows me, they know that sentencing is the hardest thing I do on this bench. First, I want to address the family has asked for the maximum prison term, which is 5 years on count 1, 5 years on count 5, to be served consecutively. I do find I could make those consecutive findings, which means the possible maximum sentence is 10 years. And I considered that. And no one addressed the consecutive findings in any of their materials. The state's not asking for consecutive, but I looked it up and I thought about it and I've considered it. But when I balance everything, I do not think a 10-year prison term is the just term here. And you don't have to agree with me, but I just want you to know I did consider it seriously. And I did think about the officers, 18 months, because I thought that was an interesting number, and I appreciate today that you've adjusted that number. And I have looked at other cases. My staff looked up other cases. I think the median average was, the median and the average was 3 years on cases like this. And I did consider probation. Ms. Nutley, I think, talked to lawyers who practice in this courthouse. I love probation. I have a 90% success rate. Of the 90% of the people I've put on probation in the last 4 years have not gone to prison. I find that to be a success. But in this situation, I believe that the proper sentence is 3 years in prison on count 1, 3 years on count 5 to be served at the same time, for an aggregate sentence of 3 years in prison. The parole board must put you on a period of post-release control of 5 years after you get out of prison. And these sentences, and you are also subject to Tier 3 sex offender reporting restrictions, which I'll go over in just a moment. I will not require that you pay any fines, but you are required to pay court costs and a $30 reparations fee. I will put in my sentencing entry, Ms. Nutley, I do take this very seriously, that there were comments that you had suicidal thoughts at one point. You went to the Lindner Center. There was comments from something I read, worried that you might have suicidal ideations yourself. So I will put in the sentencing entry that ODRC will be required to evaluate you and the jail, if you'll start at the jail, for a suicide ideation and provide all precautions necessary at the time that you're taken into custody. I want you to know, Ms. Nutley, I thought about this very seriously, and I do hope that you have hope and don't feel that this is the end of your life and career and relationship with your family, because this is a punishment and it will end, and you will come home and you will get treatment and you will have access to substance abuse and sexual offense treatment in prison and on post-release control. The post-release control period, which I said is a mandatory 5 years, as part of that, the ODRC can add additional conditions. In addition, you are not allowed to leave the state when you're on post-release control, and unless you have permission from your parole officer. The parole board can also impose any other post-release restrictions, sanctions, or financial sanctions that they choose. And if you are released from prison and placed on post-release control and you violate one of those conditions, they can send you back to prison for up to 9 months, and if you have multiple violations, they can send you back to prison for up to 50% of your stated prison term. If you commit a new felony while you're on post-release control, the parole board can send you back to prison for the remaining post-release control period, or 12 months, whichever is greater. And if you're sentenced on that new felony to prison, you'd have to finish your prison term on this case before beginning a prison term on any new case. Days of credit, you are able to earn those while you're in prison. You can earn up to 15% off your sentence. Next, I would like to go over the explanation of the duties of a register as a sex offender or a child victim offender. First of all, Ms. Nutley, you'll be a Tier 3 sex offender with notification requirements under the statute. I did not have a signed version of this form. Do you have a signed version for Ms. Nutley? Otherwise, she will need to sign it here in the courtroom.
I'll be submitted at the sentencing prepared then.
I'm going to fill this out and have her sign it when I'm done. She'll need to fill in her name and address and read and sign the form, but I'm going to go over it with her briefly. Ms. Ellie, you've been convicted of a sexually oriented offense or a child victim offense as defined by the law, and you are classified as a Tier 3 sex offender. You are required to register in person with the sheriff of the county in which you establish your residency after prison within 3 days of coming into the county. You must tell the sheriff of that county where you will be living, your education, where you'll be working, and if you have a change, you must make the sheriff aware of those changes within 3 days. You are required to provide the sheriff the temporary lodging information if your absence from the county will be for 7 days or more. After the date of the initial registration, you are required to periodically verify your residence address, employment, place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change your residence, address, place of employment, or education, you shall provide written notice of the change to the sheriff with whom you recently registered and to the sheriff in any county in which you intend to reside or work or go to school, at least 20 days prior to any change and no later than 3 days after a change of employment. Remember, employment includes volunteering. You are further advised, in accordance with federal law, you must report any international travel to the sheriff within 21 days prior to travel. Failure to do so can result in further criminal prosecution. You shall provide written notice within 3 days of any change in vehicle, email, internet, or telephone information that you have registered or you use, and you must report that to the sheriff where you registered. You are required to comply with all of these requirements as a Tier 3 offender in person every 90 days. It's my understanding when you come home, you will be living in Warren County. So this form will say that you are required to report to the sheriff in Hamilton County no later than 3 days upon your release. And the address will need to be added to the form for the sheriff registration in Warren County. So if you would fill that out, have her sign that, we'll make that part of the record today. A few more advisories for you, Ms. Nutley. This is a felony conviction. You are required to give a DNA sample to anyone authorized by state law. Failure to do so can result in further criminal punishment. You have the right to appeal my sentence. You have 30 days to file that appeal. If you cannot afford the documents or the costs, those will be waived. You are entitled to an attorney on appeal. If you cannot afford one, I'll appoint one for you at no cost to you. You can tell me now if you'd like me to appoint appellate counsel, or let me know within the next 30 days, or let your attorney know.
I'll speak with her about that, Judge. I'll let the court know.
Okay. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
Yep.
Ms. Nutley prepared to be taken in custody?
Yes, sir.
She needs to read and sign that form, and then you can take her into custody. Probably. You can come over here. Oh, I thought you should move over here. She's moving fast. Or you can back up. Copy. Shows.